Now we see distinguish between a void contract and a a void contract and a voidable contract. The first point is definition. The definition says void contract is a contract which ceases to be enforceable by law, whereas a voidable contract is enforceable at the option of aggrieved party. Aggrieved party means the victim party, the party who has been victimized. That is, some force has been applied on him or cheating has been done to him. So he becomes the victim or the aggrieved party. So, by definition, a void contract is a contract which ceases to be enforceable. It is no more enforceable because some essential is missing from it. Voidable contract is a contract wherein only one party has the right to make it void. The next is nature. Becomes void because of sudden or unexpected events. It becomes void because of sudden or unexpected. If you remember the example I gave you, it was suddenly a law was passed which banned trading in liquor. So what happened was the contract which was valid for some time suddenly became void after the law was passed. So some sudden or unexpected event happened. Let me give you one more example wherein I sell you my go down. We both enter into a contract wherein I am selling my go down to you, you are selling my go down, you are purchasing my go down. And the contract was for rupees 10 lakhs. Let's assume that. I was to hand over the possession of the go down 10 days after the agreement. So from today, if you count, after 10 days, I'll give you the keys of the go down. Now what has happened is after 2 days, our city encountered an earthquake, a major earthquake. And my go down was reduced to rubble. It was reduced to earth or mud or debris. So now there is no more go down which is in existence. What happens is this contract which started as being valid because of happening of some sudden or unexpected event becomes void because now I cannot give you the possession of the go down. So you are not required to pay me 10 lakhs. This contract becomes void because of the destruction of the subject matter. The subject matter or the main thing about which we were dealing is no more in existence. It has got destroyed. So how can we complete the contract? We cannot. So contract becomes void. How is the nature of voidable contract? It becomes voidable when the consent is acquired through coercion, undue influence, fraud, or misrepresentation. We've already studied this. When the consent is not free, that is, it is acquired on account of coercion, that is, physical pressure, or undue influence, that is, emotional pressure, or fraud, that is, cheating, or misrepresentation, that is, innocent fraud. You do not know that you are cheating the counterparty, the other party. So, when consent is acquired because of all these things, through all these things, that is coercion, undue influence, fraud, or misrepresentation, we say the contract has become voidable. What are the rights here? What are the rights of the parties? If the contract becomes void, law will not support it. So you do not have any legal remedy. You cannot go to the court of law because the law itself is saying that I'll not enforce, I'll not support, I'll not back this contract. So you do not have any legal remedy. However, in case of a voidable contract, the aggrieved party, only the aggrieved party has the legal remedy, that is, it can declare it as void. So, in case of a void contract, none of the parties have any rights or liabilities. No more rights and liabilities exist. But in case of a voidable contract, the right of the aggrieved party subsists. He has the right to make the contract void.